right, thank you for that recess, and we please call the next case.
Jospheen Guirguis et al. Versus Metropolitan Government of Nashville and Davidson County.
Good morning, Mr. Blackburn.
Good morning, Your Honor. Gary Blackburn of the Nashville Bar on behalf of the appellants. I would like to reserve 3 minutes.
3 minutes, yes, sir.
Your Honor. This presents, I told my colleagues, one of the worst things you can have in a lawsuit, an interesting legal question. It has to do an interface between the Governmental Tort Liability Act and how we determine what is the gravamen of a complaint. In most of the cases that I read, the gravamen issue has to do with statutes of limitations. There's been a great deal of litigation about that. This one has to do with several issues, including a long delay before the facts could be ascertained. What happened is that these folks they are Coptic Christians. They migrated to the United States because of religious differences, persecution, in their view, from Egypt. Mr. Guirguis had mental difficulties that evolved and developed, eventually compounded by strokes. He had an order of protection entered against him by the mother, Mrs. Guirguis, and he, of course, violated that. So he came to the condo that they had previously shared, and so Mr. Guirguis, his wife and children were there. One of the children called the police, and they came. The facts in terms of his guilt or innocence of a crime are not material. When the police came, it's clear he opened the door and he fired 2 shots. Some say he fired into the ground, some say he fired at a vehicle. The police officers reasonably could understand that they might be in danger with shots being fired in a domestic call. And so many more police were summoned. Mr. Guirguis was arrested. It took a great deal of time to resolve his case. As you know, during that time period, discovery of the criminal file is not possible. There was a study done to determine who actually had fired the shots that wounded Ms. Guirguis and children, and there was some confusion about that, but we couldn't get that. We couldn't get interviews with Mr. Guirguis because of the impending criminal charges. Well, these charges went on for a long time because of his mental decline, and he was ultimately found incompetent to stand trial and was, I wouldn't say released for time served. I think he went out to DeBerry. But at any rate, what we knew was that the police were called. There was this emergent situation, and that shots were fired. This is a condo. Growing up, I'd hear the expression shotgun house as sort of a term of opprobrium, but it's not that. It's a nice little condo, but you can open the front door and see to the back glass just through it. So determining whose shots did what was challenging. Mr. Guirguis was in the house the whole time of this incident. The wounds came during the assault, and it was ultimately determined that the officer who was in front, Mr. Garrett, was the one who had actually fired the shots that wounded the plaintiffs. But we didn't know that. What we did know is that Mr. Garrett had fired his shot without being able to visualize the target. The door was closed, and he fired into the front of the building. So what does one do then about choosing the cause of action? Well, it's very clear that it takes an intentional act to support a constitutional claim under 1983. You would not necessarily have had to intend all of the consequences, but you must have intended to do what is alleged. Negligence is not actionable under 1983. If you look at the statute that under the Governmental Tort Liability Act that excludes certain claims from prosecution as under the GTLA. That's 2920-205. It describes several things. If the injury arises out of false imprisonment, false arrest, malicious prosecution, and so forth, deceit, interference with contract rights, all of these things that are mentioned are intentional torts. The last one merely says civil rights with no further definition. So if it is assumed that these officers did not intend to harm these plaintiffs and that they fired the shots, all of them did, but in particular Mr. Garrett, they fired these shots without adhering to their own training. This is not a failure to train case. These men were trained. What we alleged was that they violated their training, and that was a tort issue that created the duty, the tort duty, or contributed to it. We filed it then under the GTLA only against the metropolitan government. Had we filed against Mr. Garrett or the other officers, we would have been confronted with a motion to dismiss based on qualified immunity. And I believe that motion would have been granted by district court or state court if they chose to have it there. So time goes on. Finally, we are able to get the discovery. We get the shooting reports and so forth. We take depositions. We're still arguing that it was simply an act of negligence and a violation of their procedures that led to the wounding of these people. Well, several years later, this incident was in 2017. The lawsuit was filed within a year of that in 2018. I think it's plain that the lawsuit, the gravamen of the lawsuit is negligence. It was defended that way. The defendant used tort defenses in the answer, including comparative fault and other things. So then the Sixth Circuit came down with an opinion in July of 2023, this Killnap case that's discussed in the papers. And it says something that's new. If you fire a shot and you strike someone other than the person whom you intended, it is an intentional act because the discharge of the gun is the intentional act, not the wounding of the individual, the strike of the individual. This was a change in the law in the Sixth Circuit. The result of that is that Metro then, having litigated this all these years as a tort claim, then filed a summary judgment motion saying, well, this is under the civil rights exception, so sovereign immunity is not waived because of that. Now, to say that this case constitutes a civil rights claim requires a lot more proof and a lot more evidence of precisely what had happened. The claim that we had presented to us in 2018 could not have been successfully pursued, except as a tort claim. Well, I would respectfully submit that the plaintiff has a right to determine what its claim is. Civil rights, as I pointed out, if you read this in para materia, this means civil rights claims means an intentional act. Well, I deposed Mr. Garrett. He's now a DEA agent in Colorado. He didn't intentionally hurt anybody. Now, he did fire in a reckless, even manner, perhaps, but perhaps not. But anyway, he admitted he fired his shot, his pistol, without visualizing the target. That is a negligence claim. So what the trial judge determined was that, well, if this becomes a civil rights claim by its nature, then this non-waiver provision of the GTLA applies. Well, how do we get to that point? Now, I agree that when case law changes the status of the law, then we follow the latter matter, the latter determination. Certainly that's true. But the cases he cited were cases in which both claims were being raised. In one instance, a civil rights claim in federal court as well as a GTLA claim in state court. These are being done at the same time. As you know, there's no respondeat superior in a civil rights claim. Therefore, we couldn't have had something that was not governed by the civil rights law imply or respondeat superior to Metro to hold Metro liable for a civil rights violation. You usually see these civil rights cases in the context of a failure to train. That's a pretty unusual situation in a county this large with a 2,000 plus police force. These men were trained. Not following the training was our claim, not a failure to train. So why would we sue the metropolitan government for a civil rights violation? We never intended to do that because we didn't have the facts or the law to support it. Now, if we're looking at this today, it'd be a more difficult circumstance. I think most any of us would bring these claims as a 1983 claim if we could, because that has no cap, like the GTLA has a cap, and it also has an award of attorney's fees. So there are practical reasons to choose that, but not if it's going to be dismissed. If you have a sovereign immunity defense that's raised, then that is immediately appealable. Now, this case has gone on so long, it wouldn't have had the impact it might otherwise have had. But if qualified immunity is raised and denied, the officer who's charged with this, and no one was in this case, has the right to appeal that immediately. It really made no sense. But I would respectfully submit that the plaintiffs, appellants, were permitted to file a claim stating what theory they believed worked for them, and they did. And now we have, because of a subsequent decision by the Sixth Circuit on only part of the case, only one of the elements of the case, we have the case dismissed because now it's assumed that it fits within the civil rights exception. So we're asking that the case be reversed and remanded for disposition.
All right, thank you, Mr. Blackman. Good morning.
Good morning. May it please the court, my name is Peter Viscarando on behalf of the appellee Metropolitan Government of Nashville and Davidson County. This court should affirm the trial court's decision granting Metro's motion for summary judgment and finding that Metro is immune from plaintiff negligence claims under the GTLA's civil rights exception. As we've just heard, there is no dispute that the MNPD officers in this case intentionally fired their weapons at an armed suspect, Michelle Guirguis, during a firefight.
There's no dispute that they intentionally fired.
That is correct.
Okay, but there is a dispute that they were negligent in hitting the plaintiffs.
Our position...
That's what Mr. Blackburn just said, so I'm trying to confirm what is disputed and is not disputed.
There's no dispute that the officers intentionally fired their weapons. There was an exchange of gunfire. The officers arrived at the home, and Mr. Guirguis had a weapon and fired his weapon, and the officers intentionally fired their weapons in response.
And it's Mr. Blackburn's position that they were negligent in doing that, and it was the negligence that injured the plaintiff.
It's Mr. Blackburn's position that this amounted to negligence. It is Metro's position that, under the case law interpreting the civil rights exception, the court must look to, not the plaintiff's characterization of his claim, but the gravamen of the complaint. And if the allegations of negligence are predicated on a civil rights violation, then the civil rights exception will apply.
So is this a negligence case or is this an intentional act case?
This is a civil rights case, and it's under the case law interpreting, the Fourth Amendment and what constitutes a seizure under the Fourth Amendment. If an officer intentionally uses force then that is a civil rights claim properly brought under the Fourth Amendment's ban on unreasonable searches and seizures. That is a proposition that goes back, contrary to what we've just heard. This is not a new development. This goes back to the 1980s at least, when the Supreme Court in Graham versus Connor first held that excessive force cases are properly brought under the Fourth Amendment. And then in Brower versus County of Inyo that same year, it said that the intent in question is not the intent that a certain result be achieved. It is the intent to commit the act. And so long as it is a willful act, not an accidental act, then even an unintended person or thing can be seized, so long as the act itself is willful.
So are you saying this Sixth Circuit case is nothing new?
Essentially, yes,
Okay.
Your Honor. There have been, so with Brower, after Brower, the U.S. Supreme Court in Brenlin versus California said that even, if an officer stops during a traffic stops a car, that even a passenger who was unknown to the officer when the stop occurred, he's seized as well. Then the Sixth Circuit in the Fisher case, which was, I believe, in 2000, said that when an officer fires at a car that was speeding towards him and hits the passenger, who's not the driver, then the passenger is seized, even though the officer wasn't intending to strike the passenger. That's a city reached a similar result in Rodriguez versus Passano, which is, I think, 10 years later. And then there are the more recent cases, including Killnap, which is the case plaintiff was referring to. But that just merely reaffirmed that was a case where officers entered a home and encountered an armed suspect, and there were two officers, and one of them fired his weapon and struck his colleague and did not strike the suspect. And the court held that the officer who was struck was seized under the Fourth Amendment, even though he obviously was not the intended target. And there's another case, Campbell versus Cheatham County, in which an officer fired at a suspect. This is very similar facts to this case, where an officer fired at an armed suspect at the door of his house, didn't strike anybody, including the man's wife, who was inside of her house, but both she and the man were seized, according to the Sixth Circuit. So again, this is nothing new. This principle has been firmly embedded in the Fourth Amendment jurisprudence for nearly 40 years.
So if it was nothing new, why did it take so long for us to get to where we are now?
Well, Your Honor, in Metro's answer to plaintiff's complaint, we asserted the civil rights exception as a defense. So this plaintiff has been on notice since 2018, when the case was first filed, that Metro was asserting the civil rights exception. Then, as plaintiff's counsel just detailed, the case was delayed for a number of years due to the criminal trial, the criminal case involving Michelle Guirguis. Once things got moving again, Metro decided to file a summary judgment motion, which it did in the time it was allowed to do.
So what you're saying is the civil rights, or your civil rights defense under the GTLA, has always been there, and your position hasn't changed, and you've been consistent throughout.
That is correct. But I would also note that even if it hadn't been raised, the Tennessee Supreme Court has said that sovereign immunity is a jurisdictional defense that cannot be waived. But Metro did assert as an affirmative, explicitly asserted as affirmative defense, the civil rights exception. So Metro believed at the time, 6 years ago, that the civil rights exception applied. And just to reiterate, in this court's jurisprudence discussing the civil rights exception, in cases like Cochran versus Town of Jonesboro and Seiler versus Scott, the civil rights exception, the GTLA is a statute waiving sovereign immunity, is to be construed narrowly, and ambiguities are to be resolved in favor of the government. In those cases, the court recognized that the the court must look to the gravamen of the complaint, not the plaintiff's characterization of his claims. So even if a plaintiff characterizes his allegations as negligence, that is not the end of the story. A plaintiff cannot evade sovereign immunity by pleading a civil rights claim as negligence. And there are cases, including the Nichols case, in which the plaintiff did not bring any civil rights claims in federal court or in state court. That was also an excessive force claim. And he just brought negligence claims. But the court held, nonetheless, that looking at the gravamen of the complaint, that this was an excessive force claim that should have been brought under the Fourth Amendment, which is what we're saying here, too. So, I think under all of this case law, it's clear that plaintiff's allegations and the undisputed facts in the record that this case sounds in civil rights. The plaintiffs have not claimed that the officers accidentally discharged their weapons, and that's a distinction that the Supreme Court has made. That an accidental act is not a seizure, but so long as there is intent to commit the act, it doesn't matter if the result isn't exactly as the officers initially intended.
So the actual intent of the officer to fire the weapon is what you say is the focus.
That is the relevant inquiry, yes. That, the officers arrived at the house and intentionally fired their weapons after perceiving the threat from Mr. Guirguis. And the fact that the bullets ultimately struck the family members does not take this out of the realm of the Fourth Amendment, as cases like the ones that I've just described make clear. And because the trial court correctly applied this law, the court should affirm the trial court's decision. And I just want to be just one more thing, just to respond to one of plaintiff's counsel's points. A failure to train claim is not the only type of a civil rights claim, especially a Fourth Amendment claim can be brought stating that an officer, that it is in fact a quintessential Fourth Amendment claim that an officer was properly trained but nonetheless used more force than was required. And that's what the plaintiff's allegation, and that is under the case law a civil rights claim. If there are no further questions, that is all I have.
Hearing none, thank you.
May it please the court, it is true that in the answer, the Metropolitan government put in a boilerplate defense on civil rights, simply stated that. However, it also admitted jurisdiction in the answer and never filed a motion stating that this is truly a civil rights claim until after the Killnap claim or case was decided. Respectfully submit this is a misinterpretation of some of the cases that counsel has cited. Perhaps I should say difference of opinion. The one in Jonesboro, if memory serves, had to do with that were too tight. That is the type of claim that's long been recognized as a civil rights claim. And that's the one that also had two lawsuits that were pending at one time, one for negligence. In this instance, this has nothing to do with facts like those in the Inyo case. I happen to be familiar with that because it's a roadblock claim, and I had a roadblock claim against the city of Greenville many years ago. In Inyo, if I pronounce that right, I-N-Y-O, they set up a roadblock around a curve, a blind curve. Their seizure was intended for that particular person, and they successfully seized him. The person came around the corner, struck the impediment. So you didn't have a negligent seizure of some person unrelated to any kind of crime or something of that nature. What Mr. Garrett testified to is that he was entitled to discharge his weapon because of the original shots that were fired, but he admitted that they went back inside and the door was closed and he could not see them, and he started firing his weapon. Those are the ones that struck the plaintiffs. Mr. Moser, Officer Moser, who's in the back, his testimony was inconsistent with another officer. He was alleging that Mr. Guirguis was about to murder his wife. These facts aren't relevant to any decision here, but that's simply not a sustainable point of view given all the testimony. He couldn't even have been in a position to see her at that time, and it's inconsistent with the other's officer's testimony. But he's raising that because that obviously would have justified him in firing the shot with her in close proximity because he's trying to save her life. I respectfully submit that the facts as we knew them stated a claim for negligence. They agreed initially that we had subject matter jurisdiction. In their answer, they never filed this motion until kidnap was decided. If you review our complaint, I think it'd be impossible to determine, or unlikely to determine, that the gravamen of that complaint did not sound at negligence.
Thank you, Mr. Blackburn. Thank you both for your arguments. We'll take this case under advisement. Call the next case.